This Honorable Court of Tennessee is now in session.
Thank you. This is the Tennessee Court of Criminal Appeals March term for West Tennessee. On the panel today, to my right, Judge Tim Easter from Williamson County, and to my left, Judge Ross Dyer from Shelby County. My name is Kerwood Witt. I'm from Monroe County. Call a case, please.
State of Tennessee versus Donald Elliott.
In this case, arguments will be 20 minutes aside. If the appellant wishes to reserve a portion of that 20 minutes for a rebuttal, please announce that at the beginning of your argument. All right, Ms. Butler.
Thank you. Good afternoon, Your Honors, and may it please the Court. Jessica Butler with the Appellate Division of the Public Defenders Conference. On behalf of the appellant, Mr. Elliott, Judge Witt, if I could, I'd like to reserve 2 minutes for rebuttal.
Yes.
Thank you, Your Honor. On October 4th of 2018, Mr. Elliott at that point was approximately 3 weeks away from his 65th birthday. He called emergency services seeking medical assistance for his grandson, who was experiencing a seizure episode. In addition to EMS and fire, police also arrived on the scene. Things quickly devolved, and when all was said and done, Mr. Elliott found himself pinned on the ground, handcuffed, and was charged with multiple offenses: assault, possession of drug paraphernalia, disorderly conduct, and resisting arrest. He was acquitted on all of those charges with the exception of the resisting, which of course he appeals today. Resisting arrest requires some show of force by a defendant. And our code has defined force as compulsion by physical power or violence. And this court has absolutely construed the term force broadly, but even under the broadest terms and in the light most favorable to the state, Mr. Elliott's actions on that day do not constitute force and therefore do not provide sufficient evidence to sustain his conviction for resisting arrest.
Ms. Butler, can I ask you a quick procedural question before you get started? So in reading your brief, defendant filed his motion for new trials denied. He timely appealed. And then after he appealed, the trial court entered an order staying the execution of the judgment. Is that correct?
I believe that is correct, Your Honor. Essentially pending the appeal.
Okay.
He was ordered to serve, I believe it was 6 days. And when he filed his motion, his notice of appeal, the court stayed the service of that 6 days pending the results of this appeal.
Okay. All right. Sorry. Thank you. Go ahead.
No, that's perfectly fine. As I said, this court has construed force broadly, but even under the broadest possible terms, Mr. Elliott's actions did not rise to the sufficient legal standard that's required for force. In our brief, we cited just over a half dozen cases from the past 30 years where this court has said these are the types of actions from a defendant that do constitute force. We have tensed muscles, jerking movements, flailing of the arms, clear attempts to evade the officer's grasp. These are the types of things that the court has traditionally held constitute force and are therefore resisting arrest. And that's simply not what we have in Mr. Elliott's case. There's nothing in the record, particularly from the arresting officer who testified at trial that Mr. Elliott, he requested, demanded that Mr. Elliott place his hands behind his back. And at no point did the officer mention any of these types of things that have traditionally been what we would think of as force and a resisting of arrest. Essentially, the officer testified that Mr. Elliott simply refused. He swore at the officer, yelled. Things were chaotic, but Mr. Elliott did not make any of these motions or any of these actions that typically would be considered resisting arrest. And if you read the cases that we've cited, Mr. Elliott's conduct is far less egregious than anything that you see in those types of cases. We also cited another case, State versus Quarter, and that's where this court has said this is the line. This absolutely does not constitute resisting arrest. To be fair, it's not a one-to-one comparison at all. Quarter, the facts are obviously distinct from Mr. Elliott's, but I do think that The Quarter case and these other cases that we've cited in our brief provide a spectrum. And if you look at the facts in Mr. Elliott's case, the facts of this case are far closer to that Quarter side of the spectrum than to these other cases that we've cited. And again, this is not just me saying it. If you look at the way that the officer described this encounter, again, nothing that he said is in line with what has traditionally been considered force. The officer says that he placed Mr. Elliott onto the ground. The court can obviously take a look at the video and see if that's an appropriate characterization, but he placed Mr. Elliott on the ground. He demanded that Mr. Elliott place his hands behind his back for some time. Multiple times he requested that Mr. Elliott place his hands behind his back. And as the officer testified, Mr. Elliott simply refused. And the reading of the officer's testimony seems as though at some point the officer simply grew tired of asking, took control of Mr. Elliott's hands and arrested him. And the video bears that out as well. Within seconds after the officer takes control of Mr. Elliott's hands, he's handcuffed, he's off the ground, the whole affair is over. The state did mention in its brief that there was also a fireman on the scene who testified that Mr. Elliott and the officer scuffled, and then Mr. Elliott resisted for a pretty good time, I think is the quote. I do want to just clarify that the scuffle comment, I think, relates to the assault, which Mr. Elliott, of course, was acquitted of. But the resisting comment, obviously that's in the record, and that's probably something that should have been objected to. But it is a legal conclusion that the fireman was not in a proper position to make. I would assume that firemen don't make it a common practice of arresting civilians. And a fireman would not have the experience, the background to make the determination about what does or does not constitute resisting as that term is legally defined.
Ms. Butler, in your brief, you cite, as you said, you cite numerous cases, but one that kind of jumped out at me that might be the most analogous to your facts was this Jackson case, which I'm not familiar with. On page 15 of your brief, it's a 95 case out of this court, but they found it sufficient where the defendant placed his hands in his overalls and two officers had to gain control over him to arrest him.
Yes.
Why is not putting the defendant on the ground and then having numerous times to ask him to put his hands behind his back, and then, as you say, the record says the officer just kind of said, "Forget it, I'll do it myself." In order to take control over him, the officer had to, and arrest him, the officer had to exert two different forces on him, I guess. Is one, put him on the ground, and then two, reach for his hand and pull it back. I mean, I haven't seen the video, but I'm assuming that's what happened. Pulling it back behind his back. Why isn't that analogous to pulling his hands out of his overalls and putting him behind his back and arresting him?
Sure. Well, Your Honor, I know that you haven't had the opportunity to view the video, but I think it's fairly clear from the video that the officer had control over Mr. Elliott for the entire course of this exchange. Mr. Elliott's pinned on the ground. The officer has his hand on his right arm, his right shoulder. So he clearly has control over Mr. Elliott. The question is whether or not Mr. Elliott is complying with his demands. And I do think that there is a distinction in the case law between failing to assist in your arrest and resisting arrest. I think it's a very fine line, but I do think that there is a distinction there in the case law. And so the officers in the Jackson case, the case seems to suggest that the officers had to struggle, there was some type of struggle where the officers had to gain control over the defendant. That's not really what we have here. Mr. Elliott wasn't going anywhere. That's for sure. And again, I think Mr. Elliott maybe didn't assist the officer in his arrest, but he certainly didn't resist arrest. I think there's a distinction there. Ignoring commands, that's not resisting arrest. Being less than willing to gleefully assent to the taking of your liberty, that's not resisting arrest. Speaking to the officer, even in demeaning terms, turning your head around and having a conversation instead of placing your hands behind your back, none of that is resisting arrest. It's absolutely not making the officer's job any easier, but it's not resisting arrest, especially when we look at the requirement of force. None of that constitutes force. And if there's no force, there's no resisting arrest. So one more point I do want to make about the fireman's testimony. Again, that's a legal conclusion. That was really something for the jury to decide, not for the fireman to decide. And again, he was not in the proper position to make that determination. He doesn't have the experience of what arresting an individual looks like. The person who did have that experience was the arresting officer, the person who was in the unique position to say, Mr. Elliott did or did not do these things. He tensed his muscles, he flailed, he tried to evade my grasp. That was the proper person to have answered those questions. And the state, I think it's fairly clear from the record that at trial, the state was more concerned with the more serious offenses. And so the resisting charge really took a back seat during these proceedings. And I think because of that, the state just didn't put on sufficient proof. If they'd asked an additional question or two, if they'd asked, did he tense his muscles? Did he tighten up? Did he try to run away, try to get away? We probably wouldn't be here. But the state never asked those questions. There's nothing on the record to indicate that Mr. Elliott acted in a manner that's consistent with how we typically or historically have viewed force. And the officer's testimony didn't exactly assist where there was a gap in the state's proof. And the fireman's testimony, I think, is such an outlier to the rest of the record. It's such an outlier to what the officer describes. It's also an outlier to what the video shows. And I don't think that, it really holds much credence if you look at the full scope of the record. But one thing I do want to point out is, the fireman was not really in a position to make that determination from a legal standard. But unfortunately, neither really was the jury. The jury instructions really just regurgitated the statutory definition that resisting required to show force, and force is defined as compulsion of physical power or violence. And that instructs the jury on what force is, but not necessarily on what force is not. And as I said, I do think that these cases that we've cited bring about a spectrum. And the cases that we cited, they sit on one end of the spectrum, the Quarter cases on another side of the spectrum. But unfortunately, the jury doesn't have the benefit of viewing all of these cases. They don't have the benefit of seeing, this is what the courts have traditionally, historically said absolutely constitutes force. And also, this is the line where they've said this absolutely does not constitute force. Anything beyond that line is not force as well. But there's a middle area, and the jury isn't really given the benefit of seeing kind of the full panoply of case law from the last 30 years. But your honors do have that opportunity. And so we would ask the court to obviously review the record, review these cases, and to see that the Elliott facts are they're far beyond what has traditionally and historically been constituted as force. And quite frankly, Your Honor, I think the concern with upholding Mr. Elliott's conviction is that it extends the definition of force really beyond where it sits already. And that's already a place that is extremely generous to the state. But there has to be some line. And I do think that Mr. Elliott's case sits almost directly just over that line. And so we're really just asking the court to maintain the line. As I said, there is a slight distinction between not assisting in your arrest and resisting arrest. And we're asking the court to maintain that line, just to not extend the definition of force beyond the outer limits where, again, it already is very generously applied for the state's benefit.
Ms. Butler, does the jury instruction on resisting arrest, I assume it defines force?
It does. So the jury instruction, as it was given, says that resisting requires to show force. And then immediately thereafter, it says force is defined as.
Okay. Does that language that you also cite, which is case law, but does that language that passive resistance generally does not constitute using force, is that in the jury instruction anywhere?
It's been a bit since I've looked at it. I don't believe that language is in the jury instruction.
Okay.
I'm not 100% sure on that, and I apologize, Your Honor. But I do not believe that language was in the jury instruction.
Okay.
So again, the concern here with upholding the conviction is that we're extending the definition of force far beyond its limits. If you look at the record, if you look at the video, I think it's clear that even in the light most favorable to the state, I think the state spends a lot of time talking about the fact that obviously under the standard, they're giving great deference with regard to what happened at the trial court level. But even in the light most favorable to the state, Mr. Elliott's actions just do not rise to that legal definition of force. And there has to, at some point, be some line, some distinction between what's resisting and what's not, what's force and what's not. And the things that we see in the video and what the officer testified to, they just don't rise to that level. So we'd ask the court to, again, maintain that distinction, review the record, and determine that the evidence is insufficient and reverse.
Thank you.
Thank you.
All right, Ms. Decker, General Decker.
Yes, may it please the court, Catherine Decker representing the state of Tennessee. There's ample evidence to support the defendant's conviction for resisting arrest. It's simple and straightforward, but before I get to that, I really need to clarify a few things that Ms. Butler has just said. First of all, doesn't fall on this court to look at other cases and compare the facts of this case to other cases. That's not what a sufficiency review involves. In this sufficiency review, we're viewing the evidence in the light most favorable to the jury, to the verdict. It is not incumbent on this court to compare the facts of other cases to this case. There's no question that the jury instruction was correct, and the state's not arguing that the definition of force has to be extended beyond what the legal definition is. That's really just a red herring. The video, when you'll see this when you see the video, nowhere does Officer Gallimore say, I'm tired of asking you. I'm just tired of asking you. I'm just going to take your hands. That is Miss Butler's personal interpretation of what might have happened, and that is not the standard of review. But nowhere in the video does that occur. Nowhere. Also concerning the Quarter case, where Miss Butler has represented to this court that this case is far closer to the Quarter spectrum. This is what the evidence in Quarter was, that the defendant was resisting arrest. This is the sole evidence. The part of the statement which is pertinent to the resisting arrest is as follows. The officers testified that while attempting to arrest the defendant refused to get into the patrol car and used obscene language. They also testified that he did not physically assault them. That's it. That's the sole amount of evidence in Quarter. Nowhere in Quarter does it talk about the officer taking down the defendant. Nowhere does it talk about a struggle. There's no evidence of a physical encounter. This case is not anywhere near Quarter. So I just setting the record straight on those important facts. So getting back to the evidence that's sufficient to support this conviction. It comes from three sources, and that is Officer Gallimore's testimony, firefighter John Mitchell's testimony, and video footage of the body cam that was on the officer's chest. And the jury is free to credit testimony from all three of those sources. And whether Ms. Butler considers firefighter Mitchell's testimony to be unbelievable, to be an outlier, that's not her prerogative to determine that. It was for the jury to accredit their firefighter Mitchell's testimony if it's so desired. And on review of sufficiency, we assume that the jury has accredited all the testimony in favor of the verdict, including firefighter Mitchell's testimony. So he testified. So in this situation, the officer Gallimore advised the defendant he was under arrest. He then tried unsuccessfully to take control of his hands so he can handcuff him. And when he was not able to do that, he took him down to the ground on a controlled takedown. So that's the beginning of this physical encounter. Firefighter Mitchell testified that Officer Gallimore and the defendant scuffled and went to the ground. Now, Ms. Butler has said, no, that evidence goes to the assault, but it doesn't have to be compartmentalized in such a way. The jury was absolutely free to determine that from this testimony that the officer and the defendant scuffled. They were in a physical encounter, and they were able to determine that that meant that the defendant was resisting. On that testimony alone, frankly, the evidence is sufficient to support the conviction. But moreover, Firefighter Mitchell then went on to say he resisted for a pretty good time. It's not a legal conclusion. It's evidence of what he saw. And it's an evidence of the physical encounter that this eyewitness saw, which is the officer and the defendant, the officer trying to take control of the defendant and the defendant physically resisting. It's not a legal conclusion. It's evidence of what he saw. Furthermore, we have a body cam video that lasts 60 seconds. It took 60 seconds for the officer to be able to take control of the defendant and put his hands behind his back and arrest him. Now, a couple of things are significant about that video. First of all, we have 60 seconds of the officer and the defendant clearly engaged in a physical encounter. And they're engaged in a physical encounter while the officer 7 times tells the defendant to put his hands behind his back. Now, the jury was free to determine that when it took 60 seconds of a physical encounter to actually make that happen, that the reason it took so long was that the defendant was resisting that. Second of all, you'll see from the video it's very jerky. And from that fact, the jury could reasonably have determined that there was a struggle going on, and that's what caused all that unsteadiness of the camera. This was not, as Ms. Butler suggests, simply passive resistance. This is not what happened. And that is very clear from the video. You also see, at a couple times in the video, that the officer is gripping the defendant's upper arm and forearm with his hands. Now, Ms. Butler has concluded that that signifies that the officer is putting pressure on the defendant. But that, of course, is not a fact. That is Ms. Butler's personal interpretation of the evidence. And that is not the proper standard of review. We are to assume that the jury made credibility findings and interpret the evidence in such a way that it supports the conviction. And interpreting it in that way, and common sense way, would be the officer trying to pull back on the defendant's arm in order to arrest him, and the defendant physically resisting, using force to resist that. You also see a couple of ways in which the defendant, and this goes to Judge Dyer's reference to Jackson, see a couple of ways in which the defendant has used his physical movement to make his arms inaccessible to the officer. And one of those ways, there's one point in the video where the officer is gripping the defendant's upper arm, and the defendant has his elbow extended, but the hand is bent inwards so that the hand is inaccessible. You also see that in the beginning of the video, at one point, one of his hands is tucked under him, and at some point, he's used his physical movements to move that hand under his whole body, and the jury was free to conclude that the defendant had used physical force to make that hand inaccessible to the officer. And then, of course, at one time, too, you can see that while the officer is saying, put your hands behind your back, put your hands behind the back, instead of doing that, the defendant at some point lifts his head up and is is saying, I'm not going to do that. And so it's, again, using physical force to resist the officer and the commands the officer is giving him. All of that evidence is to, at this point on a sufficiency review, we're supposed to defer to the credibility findings of the jury at this point, and we're supposed to defer to any contradictions, and there are none actually, but and to view the evidence in the light most favorable to the state. And with all that evidence, this court should affirm the defendant's conviction.
All right. Thank you.
Thank you.
Rebuttal. You've got a couple of minutes, Ms. Butler.
Thank you, Your Honor. This court's job ultimately is to call the balls and strikes. And there are times where the jury does get it wrong. They're rare, but there are times where the jury gets it wrong. And in those instances, this court has to rectify those. Justice requires that. So the state says that, the court is not in the position to look at the evidence and look at the cases that we've cited and determine if the jury made the appropriate decision. But that's exactly what this court is designed to do. The court is supposed to look at the evidence that the jury had. The court is supposed to read the brief, look at the legal analysis, and determine whether the jury got it right or wrong. And that's what we're asking the court to do. And again, it's our position that when you look at the evidence, when you look at the record, you look at the case law, a conviction remaining in this case would again be an extension of the definition of force. The second thing I want to point out is certainly it was not my intention to mislead the court in saying that the officer at any point said that he retired or he was done. But I think when you read the officer's testimony, that's somewhat how it reads. Certainly he never says that on video, but there is a bit of a distancing between what the officer says happened and what he demonstrates on the video. Again, he uses very conciliatory language when he talks about this exchange, that he placed Mr. Elliott against the vehicle and then placed him on the ground and asked him to put his hands behind his back and then, took his hands and handcuffed him and arrested him. And I think that that's not exactly what the video shows. But I do think that the fact that the officer had ample opportunity to give greater context to what happened. He was the person in the unique position to say what Mr. Elliott did or did not do on the ground. And he did not take the opportunity to offer the evidence that possibly could have made this conviction really a slam dunk. There is lots of case law about what does constitute resisting arrest. The officer simply does not use that language at any point in his testimony on direct examination or cross-examination. The other point I want to make is that the state mentioned that they were engaged in some type of physical altercation or combat. The only person, and I think it's very clear from the video, that the only person who was physically engaged at this point was the officer. Mr. Elliott, again, is 3 weeks away from his 65th birthday. He is pinned to the ground. There's no physical combat or there's no physical exchange between these two individuals. Mr. Elliott's on the ground. The officer had complete control over Mr. Elliott for the duration of that 60 seconds. At one point, the state mentioned that Mr. Elliott rolled over, but at the point that he rolled over, and you'll see this in the video, actually both of his hands were both visible to the officer and were within the officer's grasp. Yeah, that was true at the front of his body instead of the back of his body, but the officer certainly could have handcuffed him at that point, and that would have ended this probably 10 seconds earlier before it actually did. The other thing I do want to point out is that the state, several times in its brief, and here again, at argument, has accused me of supplanting my own interpretations for what the video shows. But I do want to point out that essentially that's exactly what the state did here and in its brief as well. There are whole sections of the state's brief, whole pages of the state's brief that are devoted to deciding what the jury could have concluded. And that's the state's interpretation of the video and the evidence. That's nothing that's backed up by the record. That's, again, the state's interpretation of the video And yet the state is accusing me of supplanting my own interpretations for what happened in the video. Ultimately, the decision lies with Your Honors. Your Honors have the opportunity to review the video, review the record, and the ultimate determination on what did or did not happen lies with you all. So that's really all that we're asking. We're asking the court to review the record. We're asking the court to use the cases that we have cited. We're asking the court to, again, maintain that there is a distinction, that there is a slight line between failing to assist an officer in your arrest and resisting arrest. It's a very slight line. It's a very thin line, but there is a line that continues to exist. And upholding Mr. Elliott's conviction would essentially eliminate that line. It would take the definition of force outside of the outer limits where it already sits in a position that is very, very generous to the state. This really could have been a very quick.
You used your time, Ms. Butler.
Thank you, Your Honor. I'll rest on that. We just asked the court to reverse.
All right, thank you. This concludes our argument in this case today. Thank you for your arguments.
Thank you.
This Honorable Court of Tennessee stands adjourned.